My names are Reverend Bishop Brethren Nebel Mumanyi. I'm a human rights paralegal. I'm talking about protection of a property. A property which is supposed to be protected is a property which has been registered. And the articles which are subjected to any property registered is Article 65 and Article 40, whereby Article 40 is subjected to Article 65. How is it subjected? It is subjected because Article 40 allows protection, allows acquiring, allows owning. And Article 65 only speaks on registration. And in the registration, it is one person or it's an individual who is supposed to be registered in a property. But it is a property where one has been registered as an individual. It has other associates. These other associates are beneficiaries. And the beneficiaries can be categorized into 4 stages. We have beneficiaries who are by birth, who are by purchase, who are by inheritance, who are by gift. All beneficiaries are treated equal because they are beneficiaries. Okay, when we come to other associates are grandchildren, grandchildren. Those are other associates who are tied to a property. And they have a right to protect. And before they protect, they must acquire, they must own. Acquiring and owning is automatic. When the registered proprietor is dead, he leaves that property there and then. But that property cannot be left because somebody has died who was registered on that property. There must people who are other associates, who are beneficiaries, they are supposed to protect. Before they protect, they must acquire in automatic manner. They must possess in an automatic manner. Because that land, when it was registered that it is being associated by other associates who are the beneficiaries. When there is a matter in court talking about to protect a property of somebody who is deceased, the Constitution has a right to protect this person, because in the Constitution is a supreme, it has its supremacy and it has its device. When the Constitution has got supremacy and it has got its device, you cannot preempt the supremacy and the device of the Constitution by use of provisions of law. For example, there is Land Act. Land Act cannot suppress the Constitution. That's a provision of law. A Constitution is a supreme law. That's why it is being said it has a supremacy and it has its demands. So the provision of law cannot suppress the Constitution. When the court is in place, the court does not work under sympathy. The court cannot work under empathy. But the court must be moved. And when you are moving the court, you have to be factual, with evidence and facts. You have to tell the court the property has got other associates. The other associates, sometimes you can call them beneficiaries. You come a beneficiary by purchase, by inheritance, by birth, by gift. You cannot be denied to protect that property. You cannot be denied because the supremacy and the defense of the Constitution allows. This is why at many times the councils, who are the advocates, they rely so much on the provisions of law. At times when you rely on the provisions of law, you fail. But when you bring in the Constitution, which is the apex law, which has its supremacy and it is divine, the court will listen you because you are factual with evidence. Some matters in court fail because several advocates or counsels, they only dwell in provisions of law. They forget about the Constitution, which is the apex, which is the supreme law. That's why people fail matters in court. Because you get a lawyer is only dwelling in provisions of law, he left out the Constitution. And as such, you lose a case. Because you are not factual. You did not move the court with facts and evidence. Then you fail the case. I'm sorry to say this. Many lawyers, they dwell so much using provisions of law. They don't use the Constitution. In land matters, we have the constitutional rights, which is being protected by Article 40 and Article 65 of the Constitution, which has supremacy and advance. At many times we lose cases in court because we don't move the court. We want the court to work under mercy, under sympathy, and under empathy. And the court cannot work under sympathy, it cannot work under empathy, but you have to move the court when you are being factual with evidence. I say, let us go back to the Constitution 2010, so that we implemented the Constitution 2010, we apply the Constitution 2010, we enforce the Constitution 2010. But at much times, we don't implement the Constitution, we don't enforce the Constitution, we don't apply the Constitution. Where it's supposed to be enforced, where it's supposed to be implemented, where it's supposed to be enforced. The court cannot work without you moving the court by telling the court that we are supposed to implement the Constitution, we are supposed to apply the Constitution, we are supposed to enforce the Constitution. Article 259 of the Constitution, it is general provision of law talking about how we can interpret the Constitution with its own principles, values. That's Article 259. It is a general provision of law talking much about the Constitution, and the Constitution must be interpreted well. And when we interpret it, we must implement it, we must enforce it, we must apply it. And who is to apply? The Kenyan system. The Kenyan system has to apply, has to implement, has to enforce. And everybody in Kenya has to do the same. Those are the areas I've talked about. In the case the other time, you will come and we talk about. Thank you.